I'm going to work backward a little bit, and the slides are in order. I don't mean I'm going to go through the slides backward, but instead of talking about what different kinds of intellectual property there are and how you can protect them, I'm going to talk about the issue that comes up most often when I see small companies or groups starting companies, and the problem that I see most often is with ownership of intellectual property, where the people who are putting together a company haven't considered how they're going to own whatever it is that they've developed. So this is a summary of the first couple of things that I'm going to talk about: who owns it, depending on what kind of intellectual property it is, what you can do so you don't lose the rights, and if you don't own it, what you need to do to get ownership. And then the last point here is just something you ought to be aware of, but I won't spend much time on, and that's once you have the ownership, how you make sure that you record the title properly. And this is really a talk about how you can avoid saying, whoops, I goofed, and I wish I'd known that before. Different kinds of intellectual property have different statutory provisions about who owns what's created. So in the case of patents, inventors are the owners. If you have an employee who invents something while an employee of the company may or may not own that. If you sign an agreement to transfer it to the company, it's not a problem, but if there isn't a written agreement, then the employee is going to own it, and the company might have a non-exclusive license to use whatever the patent covers, but they won't have the right to transfer that, and they'll only be able to use it internally, which is a big problem if your employee invents something that's important. And if you have more than one inventor on a patent application, each of the inventors owns the whole, and they can dispose of the rights by themselves, so they don't have any duty to account to the other owners. So one of the things that I often see is that a group of people will be starting a company and they'll develop some technology, and it's not clear who the inventors are if they have something that's patentable. And in the absence of an agreement among them, which can be really simple, it doesn't have to be a long agreement, but if you don't have an agreement, each of them will have a separate right. So if somebody becomes disenchanted with the deal before it's formalized, they can walk away, and that'll poison the startup of a company. It'll make it very difficult to get financing. With copyrights, it's a little bit different, because if it's created by an employee, even in the absence of a written agreement, it belongs to the company. But if it's created by somebody under contract, for example, a consulting contract, and there isn't an explicit provision to assign the rights to whoever it is that's paying for the work, the person that creates it owns the copyright. So if you have a software developer write code for an application, and they do it as an independent contractor, they own that code. And all that you have is a non-exclusive license to use that. And that's a problem that I see over and over again. And in fact, you can work that if you're the consultant. If you wait long enough and you're not pushed, sometimes you'll see that whoever it is that's paying for the development work will become so desperate that they'll just say that it's okay, you can keep the ownership, I just need a license to use it. I had a client that did that once as an independent developer, and he started a company with the code that he had written for a fairly large company. The company that paid for it got to use it with their application, but he ended up with a company that went public based on the code that he'd been paid to write for somebody else. And he was aware of that going in, and the problem was the other company had a release date that got closer and closer, and because nobody ever actually formalized the agreement, he was able to keep the rights. And in the case of copyrights, there is a duty to account to co-owners of the copyrights. So if you have people who collaborate on a work, each of them gets an equal share. So that's different from patents. Another problem is with keeping things confidential. If you're working with a group of people who aren't under an obligation to maintain things as confidential, you can lose trade secrets or you can lose patent rights if they're disclosed before you file a patent application. And finally, in the case of trademarks, those are owned by whoever it is that is using them. They can be licensed, but you only get rights through use. So there are a couple of ways that you can protect whatever it is that you're developing as intellectual property. Non-disclosure agreements are used all the time, and the materials that I provided have some examples of non-disclosure agreements. They all tend to look the same, but you need to be careful when you look at them. I'll talk about those a little bit later about what you ought to be paying attention to. Oh, okay. Well, there's a booklet of materials with agreements that I guess are outside. And there's sample invention disclosure agreements, invention assignment agreements, confidentiality agreements, consulting agreements, and some write-ups on patents, trademarks, copyrights that might be useful. Copyright notices are another way that you can protect whatever it is you have. Copyright's nice because you don't really have to do anything other than create a work to get the protection. So if you're the author of the work, the copyright automatically attaches, but you get a fairly a significant advantage if you put a copyright notice on it, because if you don't put a copyright notice on, people can take the view that it's in the public domain, and until you notify them that it's not, they're free to use it. So if somebody's relied on something that you've published or made public that doesn't have a copyright notice on it, you won't be able to stop their use. And a copyright notice is really easy to put on something. Just look at the front of a book if you ever forget what you ought to say. It's got a copyright notice. In the booklet of materials that I provided outside, there's also a trade secret notice, which we use a lot of times with software code. That's, even though there's a copyright that protects it, the trade secret rights are easier to enforce than the copyright a lot of times, because for copyright protection you have to show substantial similarity of the code that's being infringed, or to the code that's being infringed. And with trade secrets, if somebody has gotten your source code and looked at it but not copied it, you can enforce the trade secret right more simply. So these are the different situations that you might run into if you have intellectual property rights. It's really easy if you have an existing work. All you have to do is get an assignment of the right to that work, and the materials I provided have a one-page assignment that shows you basically what you need. You just have to tell what the work is or what the property is and who owns it, and say that they're selling it to somebody else. And if you get a written agreement that says that, it does pretty much everything you need to do. One of the things that you need to be careful of if you're acting as an employee is that your employer may have a right to what you do. Under the California Labor Code, companies are allowed to own anything that you develop on company time or with company resources, or that is related to the company's research or anticipated research. So if you're working for a large company or if you have a specialized expertise, you can have a big problem if you try and set up a new company while you're working for an employer. And if you're on the other side of that, you want to make sure that your employees sign agreements that say that they assign all those rights to you, because in the absence of an agreement that goes as far as the law says it will, you may end up in a situation where if they develop something patentable, you won't own it. And the last example here is joint development agreements. These are the ones that have the most interesting ownership problems, and that's probably the last thing you want to hear if you talk to a lawyer, is that you have an interesting problem, because it means that it's going to take a while to sort it out, and it's Joint development agreements, if you're in a situation where somebody else is investing in whatever it is you're developing, it's nice to have to work those issues out. But you have to look ahead and figure out where the technology might go so that you can anticipate who's going to own what portion. So you have to consider who's contributing what and what their current business is, what their likely business in the future is going to be. So it's a little tricky if you don't know what's going to be developed, and you don't want to give up too much. If you're dealing with a larger company, they're generally going to want full rights to everything. Even if they don't own it all, they may want a non-exclusive license, which means it'll be hard for you to commercialize it if it has any value, if they're an immediate competitor. So you need to be careful of that. This next slide is about how you record title in intellectual property, and this is really just to show you that there are different places where you record an ownership interest. It's a bit like recording the title to your house, and this is mostly to illustrate that it's in different places. With patents and trademarks, you can go to the Patent and Trademark Office, the Copyright Office, you can go there. For copyrights, trade secrets, there really isn't any place. But even if you record them there, that may not be sufficient. So this is the one thing that you probably want to get some advice on. If you acquire rights in intellectual property, you want to make sure that other people get a notice or are deemed to have a notice that you own it, and that means recording it in the right place. And recording a UCC1 with the Secretary of State is not difficult. Recording with the Patent and Trademark Office or the Copyright Office isn't difficult. But if you don't do it, whoever you bought the rights from can sell it to somebody else, and it may be that whoever that third purchaser is has rights superior to yours because you failed to record your title. So it's not expensive to do this, but if you get to the point where you're acquiring rights, you probably ought to have somebody who's recorded the transfers before tell you how to record them. So that's really what you ought to know before you get into a relationship with joint developers or when you set up a company. Think about who's going to own it. If you have a group of people, put it into a single entity. Get a written agreement that says how it's going to be owned. And if you ever get into a situation where you're doing a joint development agreement, think about what might be developed by each side and what you really need to own so you don't get precluded from using your own technology. The materials that I provided outside have non-disclosure agreements. If you look at non-disclosure agreements that you see in the Valley, they all tend to look the same, and one of the things that you have to be careful about is what restrictions are in those agreements that are going to what restrictions are going to continue over time, because a lot of times non-disclosure agreements will be very broad, and if you're only going to be discussing a particular technology, you ought to be as specific as possible with that. Another thing that you need to think about is when you're disclosing information to somebody else, or you're compromising any other rights that you might have, because non-disclosure agreements are notoriously difficult to enforce. So, for example, with trade secrets, you can have a non-disclosure agreement, but if you don't maintain things as confidential and stamp all the information as confidential and keep procedures in place in your business to indicate that all of that information is confidential, even though you have a non-disclosure agreement, you can be deemed to have put the information into the public domain. So I usually don't take too much comfort in having a non-disclosure agreement. I think that if you're dealing with people you know and there isn't a large group of people who are getting the information, you're relatively safe. But if it's going to a fairly wide group of people, you really ought to consider whether or not it's something that you want to disclose at all. So copyright, I said before, attaches on the creation of the work. Yes?
Hold up with companies overseas?
Well, it ought to hold up as well with companies overseas as it does with companies in the United States. If U.S. law governs. The problem is that you may not be able to sue whoever it is in the United States, or if you sue them, you may not have a remedy that is very satisfactory because they might not have assets in the United States. So in terms of enforcing it, you can get a judgment that says that somebody violated the non-disclosure agreement, but you may not get any money out of it. So it's always tricky when you're disclosing information and all you have is a non-disclosure agreement, because it's only as good as the people on the other side. And if they want to misuse the information, or if they want to start developing their own product based on information they get from you, they'll do it. So I don't know that there's any way around that. I think you just have to trust the people you do business with, and if you don't trust them, maybe you ought to look for different partners. This wasn't supposed to be an example of how not to put a copyright notice on your materials, but it is. So this doesn't have the year on it. You need to put the year. And all you really need for a copyright notice is the little C in a circle, the year, and the name of the owner of the work. In the United States, you see people put copyright before it, but internationally, the little C in a circle is recognized, and the word copyright isn't. So if you want to have a notice that works in any country that's a party to the Convention on Copyrights, there are 200 countries that are parties. I don't know of any significant country that isn't. Put the little C in a circle, the year of creation of the work, the name of the owner. All rights reserved isn't something that you need. You see that all the time, and that's really an historical artifact. Once upon a time, Argentina wasn't a member of the Copyright Convention, and you needed to reserve all rights in Argentina. And you see that all the time on materials, but you don't need it in Argentina anymore, and you don't need it anywhere else. But it's always in the front of books. And as I said before, if you're not sure what to use, look at the front of a book or any other publication. Don't look at this page. So moving on to trade secrets, I mentioned that they can be really hard to enforce. It's hard to make a trade secret claim stick unless you have evidence that somebody has taken things and it's red-handed. So if somebody takes a hard drive and goes to a new company and they're using the information on the hard drive, that's an easy case. But in the absence of that kind of evidence, the only way you're going to be able to enforce a trade secret is if you can prove that you've taken all the procedures to maintain the confidentiality of the information and that it isn't in the public domain. So even if somebody took it and they weren't authorized to, if that information is available from other sources in the public, you can't make a trade secret claim stand up. That's a question.
I've heard that most venture capitalists refuse to sign non-disclosure agreements. If that's the case, then how could you ever protect the trade secret if you're going to try to commercialize it and you try to discuss it with the VC and they won't sign a non-disclosure agreement? Isn't that a lapse in the protection?
Well, I think it's a question of degree, because I think that's accurate. They're not going to sign a non-disclosure agreement, not unless you get into very technical information. So the kind of materials that you typically see in a pitch to venture capitalists are pretty high level. If you have the kind of idea that once you see a few slides, it's immediately obvious that that's a great idea and, gee, nobody's thought of that, and it's not under a non-disclosure agreement, you're out of luck. Most things aren't like that. Some things are. If that's the case, the best way to protect yourself is to file a patent application if it's patentable. And if it's something that you really want to maintain as a trade secret rather than patenting because you figure that patent's going to be difficult to enforce in whatever the field is, and in some areas it's hard to enforce patents. Software is a place where you might not want to have to enforce a patent, where the work in reverse engineering a software application, if it's maintained as a trade secret, would be pretty substantial. If you're in that kind of a situation, what you could do is file a provisional patent application it's not examined, and it gives you really a placeholder for a year. So if you're fairly early on in the process and you file a provisional application, you're protected to the extent that later on you might be able to patent it. But I'm not sure that there's a good answer to that, because you have to talk to people if you're going to get partners. And I think there are degrees of disclosure. So most of the things that I see that are presented as business plans and that are presented to venture capitalists and looking for financing aren't at a level that somebody could use them to build a product. And I think, you know, as you get later on in the diligence, if somebody's really going to put money into the company, you have to provide more information. At that point, I guess it gets riskier. Yes.
Is there ever a case where you have something that's both a trade secret and covered by copyright, or those kind of
all the time? Software programs are a good example. So what you often see on software programs in the license agreement is a copyright notice as well as a trade secret notice. So if it's something where, in fact, I've seen materials that are licensed by providers that say that they're trade secrets. So if somebody, the place that I've seen it most often is in business services, where a consultant wants to provide some kind of a service to a company, but he doesn't want everybody to use his materials. And so when he works with a company, he will get them to agree that they won't disclose the materials that he's given them. So it's protected by copyright, but the real issue is if you get my 500-page workbook and you look at it and you see my procedure for whatever it is I'm going to do in analyzing your business, you don't have to infringe the copyright in order to get all the ideas in there and rephrase them. So copyright's really a very narrow protection. The only way that you'll be able to enforce a copyright is if the materials have substantial similarity, which means unless somebody copies it, you don't really have a claim. And so if you have something that's text, unless there's text that is either identical or very closely paraphrased, it's not going to be a copyright infringement. I'll get your question in a second. There was a line of cases about 15 years ago in user interfaces for computer programs where people claimed that the user interface was copyrightable. And that's been very narrowly construed, where you would have gotten broader protection. For example, on the icons on a screen, sorts of icons can be used, but that's kind of gone away. So it's really got to be almost an identical copy these days.
So you talked about lapses in security on trade secrets. More broadly, are there cases where lapses in enforcement in any aspect of intellectual property could cause you to begin to lose your rights?
Yes. So I guess it depends on the kind of intellectual property it is. If you let your trade secrets get out, they're public and you're just out of luck. There's not much you can do to recover a trade secret once it's lost. You can sue whoever disclosed it for damages, but it's hard to put the horse back in the barn in those cases. In the case of patents, you don't have an obligation to enforce them, but if you send people letters that say, we think you might be interested in taking a license from us, or we think you're infringing our patent, why don't you pay us some money, and people ignore you, if you wait too long, you may be deemed to have given up your rights to enforce it. If somebody has, been given notice and 6 years later you come back and sue them for infringement, the courts now have said that may be laches, which means that you've sat on your rights too long and haven't enforced it. That's actually fairly new in the case of patents, and it's kind of unique. I mean, it's unique to the case of Jerome Leopold, who you may not be familiar with, but was famous for filing patent applications in the 1950s and then extending those under the old system of patents, where patents were valid 17 years from issue rather than 20 years from the first filing date. And he really abused that process and made hundreds of millions of dollars on applications filed in the 50s. So the U.S. law was changed to conform to international standards or what everybody else does to have the patent term go from the date of filing rather than the date of issue. We get rid of Lemelson's submarine patents. Lemelson's patents are still out there, and it's kind of funny that there's a change in the law really to address that one abuse, but that's where the doctrine of laches and patent enforcement goes too, because courts have said in Lemelson patent cases that you waited too long to come after people. So, frankly, it's not very satisfactory intellectually that the law's been changed to address one specific abuse that was taken care of when they changed the law on the term of the patents. And the standards aren't very clear on what is too long for not enforcing a patent, but you have to deal with that now. It's not something I rely on as an infringer, that if I do it long enough, I'll be okay. In the case of trademarks, it's the same thing. If somebody uses your trademark and you don't stop them, you may lose the right to stop them from continuing use. The other side that I see this issue come up from is from employees who were thinking about starting new companies. I said at the beginning that one of the most common problems that I see is ownership of intellectual property in new companies. The other thing that I see all the time is employees who have problems with claims from their prior employers. And if you get this, it'll poison any kind of financing that you have in place. And if you get a lawsuit that says that you've taken trade secrets, it'll pretty much stop a startup before anything happens. So if you're an employee of a company and you're planning on setting up a new business, what you really ought to do is leave the employer before you start doing the work on the company, so that your prior employer won't have any ownership rights in what you do. And that's kind of a hard leap of faith to make, but it'll make the transition a lot cleaner. So you don't want to take any documents with you. You don't want to take any customer lists, anything at all. You don't want to leave on bad terms, even if you feel like telling people that you weren't happy. And you don't want to tell them what you're going to do, because that'll make people suspicious of what you've been doing before you left. So there really isn't a bright line for how long you should be away from a company before you start filing patent applications and developing new technology. But if you immediately file patent applications after you leave an employer, everything's ready. Or if you immediately get financing on a new venture that's in the same business as your prior employer, it's going to raise eyebrows. So I think it's a little bit like getting married after your spouse dies. There probably ought to be a decent interval, and I don't know how long that is, but next week isn't enough time. Just talking more substantively about intellectual property law, this is kind of an outline of trademark law. So trademarks go from arbitrary marks that are very distinctive and easy to protect to marks that companies like to use because they tell customers what their products are, which are descriptive and hard to protect. So something like United Parcel Service over time has become distinctive. But if you have a trademark or a company name that sounds like it's describing what you do, or that uses a lot of terms that are common in your business, it'll be hard to stop other people from using things that are very similar. So at some point you have to trade off the advantage of telling people what you do against the disadvantage of not being able to stop people from using things that are very similar. And the two examples on here of generic marks, escalator and aspirin, are kind of famous examples of trademark rights that were lost because other people started to use these as generic terms. So aspirin and escalator both were proprietary names where the protection was lost because they became the generic name for those products. Xerox is another one where it came pretty close, even though it was coined term, to being a generic term. And Xerox, about 15 years ago, had a big campaign to recover Xerox as a trademark because everybody said they were going to Xerox something, or they'd use it as a verb or a noun for any kind of photocopy. That's actually been pretty successful. I didn't think it would be, but now when people talk about making copies, they talk about making photocopies, not Xeroxes. And I don't know if that's just a reflection of market reality that they don't have such a dominant market share anymore, or if they were successful. It's one or the other. But my daughters say photocopy, they don't say Xerox. Patent applications, I had a question at the beginning about what kinds of patent applications there are, what kinds of patents there are. So what I've listed here relate to utility patents. The question was, what kinds of patents are there? And utility patents are patents that cover how something is used, so that, a product or a method. There are design patents. There aren't nearly as many design patents as there are utility patents. So when people usually talk about patents, they're talking about utility patents. Design patents can be really useful, and they're actually pretty simple. So if you have a product that is distinct in the way it looks, it might be worth filing a design patent on it because they're cheap. All you have to do is file drawings. They usually go through the patent office with fairly little examination, and then if somebody knocks off your product, you can enforce the rights. So the place that you see design patents used a lot is in things like shoes. Nike files lots of design patents, either on the way the shoe looks from the side or from the bottom, the way the treads are. Computer peripherals have lots of design patents filed on them. So anything that has an ornamental design that's distinctive can be protected, and you'd be surprised at how low the threshold is for distinctiveness. It's pretty easy to get a design patent. If somebody knocks off your product, it can be really valuable because it's pretty straightforward to enforce them. Another kind of patent is a plant patent, and I've never done a plant patent. They cover, I think, asexually reproduced plants, so things that you buy at a nursery that are hybrid plants, like roses, trees, things like that are covered by plant patents. But I've never done one. I've seen them. They're really nice because they have color pictures of the plants. So they're the nicest ones to look at. The more common ones are utility patent applications or utility patents, which cover methods for doing things or devices, products. Under U.S. law, you can now file a provisional patent application, which doesn't have to be a formal application. I mentioned that earlier. If you're going to be disclosing technology to somebody, you can file a provisional patent application pretty quickly. The standard of disclosure is the same as it would be for a regular non-provisional application, but it doesn't have to be put together in the same formal way that a patent application that's going to be examined does. So if you have product information or manuals, it's pretty easy to file that, and if it's enough to show somebody in that field how you would reproduce the invention, it's sufficient for the disclosure standards for the patent office. So we do that a lot with startup companies because one of the things that it allows you to do is see how your technology is going to change over time. Provisional application gives you a placeholder for a year, and you can file a non-provisional based on that up to a year after your initial filing. So sometimes it makes sense to see how your strategy changes over time, and you can file a series of provisionals over a year and then roll them together at the end and file a single non-provisional application that covers what you're really going to do rather than what you thought you were going to do a year ago. So it's a nice way to save money, and it's kind of makes sense because you don't waste a lot of time putting together formal patent applications on things that may never be used. Filing fee's cheaper. It's only, it's $200 now for a large entity, which is a company with more than 500 employees or that licenses, if you license to a company with more than 500 employees. For regular non-provisional applications, the filing fee is a little over $500 now for small entities, a little over $1,000 for large entities. So it's non-trivial. And the amount of work that goes into it, if you have a patent attorney do it, it's going to be a lot less. So in terms of filing, it's probably less than $1,000 if you put together good disclosure materials for a provisional application, and $12,000 to $15,000 if you file a non-provisional application. So there's a big difference in the cost. The filing fees, I guess it's the same order of magnitude, but the difference between $200 and $1,000 isn't nearly as great as between $1,000 and $12,000. So anyway, I file lots of provisional applications for startup companies just because it makes sense to do it that way. Yes.
Are the contents of the provisional patent considered public domain if you do not follow up with a non-provisional patent afterwards?
No, they're not, and that's one of the other advantages of it. It's never examined, it's never public, unless a patent issues it's based on that provisional application. So if you want to maintain it as a trade secret, you can decide not to file it. If you decide that you're really not ready to go ahead with that idea, it sort of dies in the patent office, you haven't lost your rights to file a patent application later. The risk you take is somebody else will invent the same thing. So as long as you've kept it confidential and haven't disclosed it publicly, you can file a new provisional later if you're coming back to that idea later on. The risk you take is somebody else is going to decide to do whatever it was that you had put in the patent application. The United States has a grace period for patents, so that 1 year after you disclose an invention or sell a product that is covered by a patent application, you lose the rights to file. So the United States is a lot more generous than foreign jurisdictions. And in other countries, there isn't any grace period. So if you sell a product or if you disclose how to make the product or what the invention is, publish a paper, you'll lose your rights to foreign file. So that's one of the reasons that you probably want to have a pretty close look, at least a couple of months before you start providing a product or a service that you think might be patentable. Check out whether or not it's something that you ought to file a patent application to preserve the right to file foreign. And for a small company, it can be really expensive to file foreign patent applications. You may not want to do it, but it's nice to preserve the option, and you can do that pretty inexpensively if you file a provisional application. It has an advantage if you ever look for outside financing or if your company is acquired, because if you're acquired by a larger company, they'll have the resources to file in foreign countries. And for some industries, it's very important. In semiconductor processing, it's pretty important. For pharmaceuticals, it's very important. In most electronics applications, it's someplace. People file in Europe, Korea, Japan, China. Some things get filed all over the world. But other technologies, it's not that important.
In addition to the work that you do as an attorney in terms of crafting the application, I suppose you do some work researching the related IP space in terms of what trying to carve out exactly what can be protected. I'm wondering if you could talk a little bit about that in terms of what type of work that involves, or when does that happen in the provisional versus non-provisional? Do you go and spend time when you craft the provisional application trying to understand neighboring technologies and where exactly to position that application relative to those?
The question is, do we spend time when we're working on patent applications figuring out what the related technologies are in the prior art in order to develop a strategy for protecting a company's technology? And I guess in the case of provisional applications, we don't do that. And there are different things that you can do. People often talk about getting a patent search done. Sometimes we do patent searches with the online tools that are available now. You can go to the Patent Office website. It's uspto.gov, and you can search U.S. patents there just with keyword searching, which really isn't that effective, but you can find things that are related. Or if you know companies that are active in an area, you can find some pretty good prior art. Prior art searching is not very effective for software because there isn't a unique way to describe software applications, so you can have two identical applications or two identical inventions described in very different words, and so using a keyword search doesn't work at all. For some things it works really well, so that's a good place to start. We don't do that for provisional applications because usually the point is to minimize the cost and the amount of time that's spent on it. Usually with people who are working in a technology where they're very familiar with it, we don't do prior art searches. And the reason is that the inventors are going to be more familiar with the prior art than anything we would be able to find by searching patents or literature. So current developments aren't going to be in issued patents or public patents. So people who are really up on the technology know it very well. And we usually rely on them. With individual inventors who probably don't have that level of sophistication in technology, we do more. And frankly, with older technologies, we do more searching because there's more out there and it's more likely to be relevant. So if it's something that, it's really been developed in the last 3 years, it doesn't do very much good searching prior art. You can find better information by looking at what competitors are doing. Now, in terms of crafting an application so that it covers technology effectively, that's something we do all the time, particularly when we're drafting non-provisional applications, because what you want to find out is what you can cover that will be a key in preventing other people from using your technology. So everybody wants to have broad patents, and broad patents are nice to have, but most of the time you can't really get broad patents because you don't have revolutionary technology. Sometimes it's nice to have really good narrow patents. I had a patent once that I sold out of a bankruptcy estate that the sale was, I think, in 1995. The patent issued in 1982, and it had been filed in 1979, something like that. And it had been sold a couple of times with the assets of a couple of bankrupt disk drive companies. And the patent was on a filter in the housing where the disk spun, because when a hard drive spins, you can get particulate that'll mess up the disk. Well, every hard drive has those filters. So it turned out that this patent that was really on a pretty narrow application was really valuable. So if you can find something like that, it's great to have a good narrow patent, and they're a lot easier to enforce because people aren't going to challenge it and say, oh my God, how could the patent office have issued a patent on that, which is the reaction you get to a very broad patent. I can't believe that this is enforceable. So you have to look at that. The other thing that inventors tend not to do is look at alternatives to the way they've solved a problem. So if you're developing a patent strategy, what you want to do is, once you've focused on what works, look at what the alternatives are that people could use to design around your approach. And another thing that is really worth the time, if you've got it, and it doesn't often happen in startup companies because they're so focused on getting a product, but when a company gets a little bit larger, it's nice to look at what your competitors are doing and patent improvements, because that way, if they ever think that you need to take a license to their technology, you can offer them a license to what you've got that covers what they're doing, which is a nice result if you have a little bit of leverage. That's all I had in the slides. Happy to take questions.
Your perspective on freedom to practice rather than just patentability, and how young inventors are looking at that issue?
Depends on the industry. And in some industries, people don't really worry very much about freedom to practice. It's hard to really find a field in which you're going to be absolutely clean of infringement of patents. And at some point, maybe you don't want too much knowledge about what patents are out there, because once you've got them, you're deemed to have knowledge. Once you know about them, you're deemed to have knowledge, and then if you infringe them, it's willful infringement. So sometimes you don't want to know about that, and I think that's kind of the view that people in the electronics industry take. They'll know who their competitors are. They know who's aggressive in enforcing patents, and they'll want to know what's going on with those. In biotechnology and in pharmaceuticals, there is a lot more emphasis on freedom to practice, because if you develop a drug and it costs you $1 billion to get there, you don't want to be blocked from putting it on the market. So people in those industries invest a lot more money in freedom to practice. And I also think there's a real difference culturally. In the United States, people tend to take the view that they'll work it out, that you'll find a deal, or somebody says you're infringing my patent. Well, it's an opportunity to talk to them. My experience, I can't tell you that I've had a huge amount of experience with a bunch of countries, but I've had experience with French companies and German companies where they've taken a very, very conservative approach in fields where it was really necessary. So they wanted to do freedom to practice studies in fields where 5 or 6 companies own very closely related, or very close patents on semiconductor processing technology and chemicals used in semiconductor processing, where it's pretty clear from the number of patents that are issued that slight variations are viewed as being patentable, which tells you it's a very crowded art and it's going to be hard to enforce any of those. And in separate negotiations, a couple of times I've had German and French companies back away from deals where I thought the risk was very low. So I think, at least in Silicon Valley, people are a lot more aggressive about it unless they know they've got a competitor that's going to try and put them out of business. So it kind of depends on the competitive landscape.
What is freedom to practice?
Oh, sorry. Freedom to practice means looking at other people's patents and figuring out whether or not you infringe their patents, so that if you're putting together a product, you want to make sure that nobody can enjoin you from putting the product on the market. And that can be really important. I think about 15 years ago, Kodak developed a camera that took instant pictures like Polaroid, and Polaroid enforced its patents, and Kodak had to withdraw the product, destroy everything that they developed. It was a huge product development for Kodak, and it was all lost because they had, I don't know, a judgment of $100 and some million 20 years ago, and they were enjoined from that. So in certain fields, it can make a big difference. And I guess it depends on the strength of your competitors, how much they want to put you out of business. Any other questions? Okay, thanks. Allison Tilley is going to talk now about stock option programs.
I'm going to switch gears here. So I see several faces that have been here at the other sessions, so you guys are diehards, and thanks for continuing to come. At the other sessions, I covered the first time forming agreements, forming companies, founders agreements, when and where to incorporate. The second session, we covered financings, and one of the items that's pretty important in a startup company is options. So we're going to cover that tonight. And then at the end of the session, if you have any questions about any of the other sessions, feel free to bring them up as well. So many people will say that stock options are what made the Silicon Valley. The ability to grant stock options to employees, not pay them too much money, have them invest in the hopes that they'll be multimillionaires is what made the Valley what it is. But today, with all the new tax and regulatory changes, there's a big question about what will be the future of stock options. So first of all, what is a stock option? A stock option is a right to buy stock, a specified number of shares, at a specified price at a later date. It could be a right to buy them right now, but they usually have some vesting period. And then they usually have a term. Statutorily, stock options can't be longer than 10 years. So it's usually common stock. There's no reason you can't have a stock option to purchase preferred stock, but that's just not usually how it's done. It needs to be pursuant to a stock option plan. And stock options are one of those areas of law that's really the convergence of many different things. There's corporate considerations, there's tax considerations, and then there's the stock option laws that you have to comply with. So stock option plans are one of those things that you really get what you pay for, and you need to hire someone to do them. You can't write them yourself. There's all sorts of provisions that you need to have, or they're not going to work. So it's something to be very careful about. The stock option plan, once it's written, it has to be approved by the board, and it has to be approved by the stockholders. I can't tell you how many startup companies we have that get formed, they create a stock option plan, they go off and they start issuing stock options, and they never got stockholder approval. You have 1 year from the date the plan is approved by the board, to get shareholder approval. And if you don't, that means that all the stock options that you issued under the plan are no good. So you have a big problem, because you have these employees who are holding these contractual rights to stock, but you don't really truly have a stock option. Options are usually issued to employees, consultants, advisors, and directors. It must be a living, breathing human being. You're not allowed to issue stock options to entities.
You said approval is required by the board of directors, but also by the shareholders too?
Yes.
Both groups have to approve.
Both groups have to approve. So the approval starts at the board level because the board has to approve it in order to put it forth to the stockholders, and then the stockholders approve. Statutorily, the stockholder approval is a majority of stockholders, but sometimes when you have preferred stock, they'll have asked for a right to have a vote themselves. So you might need a majority of all the stock and a majority of the Series A. So that's something to be careful of to make sure you got the right thresholds.
About the grading email, if it was an entity, we call it warrant, and then we have time periods, or am I right there?
Well, an entity, I'll talk a little bit in a few minutes about the differences between options and warrants, but you cannot issue a warrant under a stock option plan. And you have different regulatory considerations for a warrant, which we can go over in a minute. What often happens is you'll hire a consulting firm to do your web design, say, and they're XYZ web designers, and so you'll issue an option to them. That often happens before a client comes to us. We'll see they've issued all sorts of options to entities, and that just doesn't work. It's not a valid option. So what we suggest in that instance is that you ask the principals of that entity to let you issue the options in their individual names. So let's say that web design firm has 3 people, and they tell you, okay, issue this option, this many shares to this person, this many shares to that person, and so on. So that's one of the better ways to handle it, but we can talk about warrants in a minute.
At what point can the options be issued to an entity, if ever?
Never.
Never.
The option will be permitted. I don't really know why. I don't know why they care, but they don't. So options usually have vesting. They're often considered a motivational tool. There wouldn't be a lot of reason to give an employee a stock option without vesting. You want them to stick around to earn it. A typical vesting program is 4 years. Often there's a 1-year cliff, and what that means is that there's no vesting till the end of the first year, and then usually 25% of it vests. People often like to have vesting based on milestones or performance. That's pretty tricky. There's all sorts of rules about that, so you have to be careful. In California, the Department of Corporations requires that options vest no less frequently than 20% a year over 5 years. You can have performance options for executives, but that's something definitely, if you want to do it, once again, you should talk to somebody. The vesting can be any structure you want. You could have it vest over 1 year. You could have it vest over 3 months. Your vesting could start a year ago. Your option cannot be granted until the person starts, but the vesting can go back. So another issue that we see come up a lot is you'll have given somebody an offer to join, and so then you approve an option to them. Well, they weren't technically an employee when you approved the option. They may have accepted an offer letter, but they haven't started. So you really need to make careful that your timing is correct, and you don't do it till they're actually an employee. And then usually there's a period to exercise the option following termination. Usually it's 3 months. Statutorily, it has to be 3 months or less for an incentive stock option. It can be longer than that for a non-statutory stock option. And without getting too much into the regulations, an incentive stock option can only be given to an employee, and it has better tax implications for the employee than a non-statutory stock option. Non-statutory stock options can be given to employees or consultants or directors, but incentive stock options can't. On the regulatory front, you really have to make sure that your options and your option plans comply with all the laws, and I won't bore you with what they are, but there's federal level compliance that's required, and there's state level compliance. And the state level compliance comes into place both of where you're issuing the options from. So if you're a Delaware company but you're doing business in California, you need to comply with California law. But then you're issuing options to Linda, who lives in Utah, you've got to comply with Utah law too. So you really need to make sure that you're complying with the laws of all the different places that you're touching. And if you want an example of why that's so important, I don't know how many of you read in the news, when Google went public, they had violated the federal Rule 701 laws, and they had to do a rescission offer for $25.9 million. The general counsel of Google was brought up in front of the SEC and sanctioned, as were executives of the company and the company itself. So it can be a serious thing. Now, at the end of the day, to Google's benefit, since their stock was doing so well, no one took them up on the rescission offer, but it obviously could have been a big deal. And what a rescission offer is you have to give a person a right to have their money back. In the option context, if you have an option and you haven't exercised it, so you haven't really parted with money, the regulators still require you to put some value on that. So you could have an option, you have not exercised, you haven't paid a penny for it, there was a securities law violation in giving it to you, and you might have to be paid to remedy that. So then also, you really need to understand the tax issues surrounding options. And once again, I'm not going to go into that in detail because that's a whole session in and of itself, and you'd all fall asleep. But there's different tax impacts for the incentive stock options, and there's different tax impacts for the non-statutory. And you also have to be very careful with alternative minimum tax, because even incentive stock options, which many people think are completely non-taxable until you sell the underlying stock and make a gain, that's not the case. In certain circumstances, if you exercise your option and hold the stock, you could be subject to alternative minimum tax. A lot of that depends on the value of the stock. It depends on your personal tax situation. But that's something that hit a lot of people in the boom. They exercised stock options because they wanted to start the holding period so they could get capital gains. And ultimately, the company went under and they got nothing. But they were taxed on the spread of the option. So let's say they had a 10-cent option. It was worth $1 when they exercised it. And they had 100,000 of them. They never got any money for selling the stock because the company went under. But they're taxed on the 90-cent per share delta when they exercised it. So that's definitely something that you need to make sure you understand. So as I mentioned, you need board approval to approve the option plan, and you need board approval to grant the options. Only the board can grant stock options. Lots of times people will go out, they'll promise options. They might write an offer letter that says you'll get 10,000 shares of stock or options to purchase 10,000 shares of stock. That is not valid unless the board approves it. So you need to make sure that you take all the steps for the board to approve it. And then once it's approved, you need to make sure that you actually document it, give the optionee the paperwork, get them to sign it. We had a company recently which we sold, and they had issued tons and tons of options, and they actually were even pretty good. They prepared option agreements for all of the people, and they passed them out. But they didn't make sure that the people signed the option agreements and turned them back in. So now that this company was being sold and the stock was worth something, someone came out of the woodwork and said, I'd like to exercise my stock option. And I said, well, you can't. You quit 2 years ago. The option has a 3-month exercise period. You didn't exercise it, and so it's too late. And they said, prove that I only had a 3-month exercise period. And the company said, what's right here in the stock option agreement? And I said, prove that you ever told me that. Prove that you ever showed me that. The company could not prove that because they had handed them out to the employees, so they didn't have an email trail of delivering the document. They hadn't had the person sign it and return it, and so they ended up paying her $45,000. Employee who'd left 2 years ago and never exercised their stock. So that is a trap that many, many startups fall into. They're not careful about their paperwork, so it's really important to do so. You should always prepare a stock option budget. And if you look at the handouts from the first session, which I believe are on the website, you'll see some examples of budgets. And like I said then, those are not the Bible. Those are just ideas. Every company is a little bit different. Every industry is a little bit different. But it will show you how you should list out the people that you have and how many shares you want to give them. And you should remember that there basically are no secrets. As they say, 2 people can keep a secret if 1 person is dead. And that's pretty much the truth in compensation and options. We had a client who their option ledger got out. Was quickly, in these days of emails, things are pretty much around the world in seconds. Every employee in the company saw what every other employee got. And the CEO told me that for 2 days, absolutely no work got done in that company. Everybody was talking to everybody, comparing options, asking why Dave has more options than I do. And the scars of that actually lasted for the life of the company. There were people who even quit over it because they weren't happy with their relative holdings to others. So you should do everything you can to keep the option records secret, to keep them private, to really respect them almost like a trade secret. Do what you can to make sure they don't get general distribution because it can be very harmful. Next question, how much stock is enough? And that's an unanswerable question. That's a how long is a piece of string question. You have to figure out what the person's doing, what they're doing in the company relative to somebody else, what the market cost is for hiring a person with those skills, and you have to balance it all out. You also have to understand that the first grant you give them is not the only stock they'll ever have in the company. Usually what happens is a grant is made when somebody's hired, and then over time, if let's say it's 3 years into it, the company is doing well, this person's almost completely vested, you want them to stay, there's often something that's called refresh grants. So the board will go through and issue new grants to all the people who've been around for quite some time. So you want to balance your desire to motivate them with enough stock and your need to not give out all of the stock of the company in the first round. And that's my next point, beware of idle promises. You have to be careful that you don't promise 2% here and 5% there and 10% there, and the next thing you know, you've promised 150% of the company. And one of the ways that really gets people into trouble is they'll be starting a company. Someone will help them. Once again, we'll go back to that web design, so help them set up their website. And you promise them 2% of the stock. Well, what does that mean? 2% when? 2% now, 2% after the Series A, 2% forever. So you really need to be careful with what you're promising. We see people they tried very careful to make sure they documented it. They entered into a consulting agreement with this web designer, and it says right in there they'll get 2% of the stock. And there is definitely an argument, if that's all it says, 2% of the stock, that it's a perpetual evergreen, and whenever you issue new stock, you have to issue them some more to get them back up to 2%. So it's something to be very careful of. Another trap I see a lot of people fall into is advisors. If one advisor is good, aren't 10 advisors great? Look at me when I pitch my company. I've got 10 advisors. Aren't they impressive? And yeah, they often are. But what are they really going to do for your company? People often try to get as many people on their advisory board as possible. They issue them all stock options. And at the end of the day, very few of them really spend the time and help the company. So you need to be careful that you don't, when you're forming the company, you don't sign on a bunch of advisors, promise them all a bunch of stock, and then not get the benefit from them. At a minimum, you should make sure there's vesting on their stock, so if they're really not helping you, you don't have to continue giving them the stock. The next question is pricing. How do you price a stock option? And the statutory requirement is that a stock option is priced at the fair market value of the stock at the date of grant. So if I'm giving you a stock option today, we have to look at the price of the stock today. For a public company, that's very easy. If I'm Google, once again, I look at what the market close was, and I know what the stock price is. For a private company, that's very difficult. Nobody really knows what the price is. a common practice that's followed in the Valley is that stock options are priced at 10% of the price of the preferred. Now, no accountant will tell you that that's, a protectable amount. It's just a typical amount that people often do. The argument is that common stock is clearly not as valuable as preferred stock. Preferred stock has liquidation preferences, they have voting preferences, they get their money out first, they might have directors. So it's very clear that common stock is less valuable than preferred. But the question is truly how much less valuable. People, like I said, have generally been using that 10% rule. As you get closer to a public offering, people start ramping up their price. But the new regulations, I think, are really going to call this into question. Under Section 409A of the new tax code, the new rules say that if you don't issue an option at its fair market value, the delta is compensation. So if I issue you an option today at 10 cents, and the IRS later says, no, that was worth 50 cents, 40 cents per share is deemed to be compensation to you. You're immediately taxed on it, and there are penalties. So these new rules that have come out governing options are really going to put a lot of pressure on the price. I can't tell you at this point how it's all going to pan out, but that's something to be very aware of, to talk to your accountants and lawyers about before you price the options. To your question, what's the difference between an option and a warrant? In general, there's not a difference. They are both rights to buy stock in the future for a specified price and a specified number of shares. But in general, stock options are what are given to employees, and they're done under the option plans, and warrants are what are given to other people, and they're not under an option plan. They're not under a plan at all. You might give warrants to a landlord, to a bank who's given you a financing line. And the big difference is when you're issuing the shares, like I mentioned, you have to comply with securities laws. And if you're issuing stock options to 20 or 50 employees, it's very difficult to comply with the securities laws for each and every one of them, because a lot of it depends on their sophistication and whether they're an accredited investor and things like that. So the option laws provide that if you create a plan and it meets all the requirements and you make certain filings with the state, then you can issue an option to any employee, consultant, director, or advisor. So that's the real benefit to using options, is you've basically got this blanket protection under the securities laws. And then the warrants you would use when you needed to. The reason you might not want to be giving the warrants to the consultant is you might not want to have to go through the trouble of figuring out if they have the financial means and if they can meet all the criteria outside an option plan to qualify to receive stock. So how do options and option pools sort of affect your life as you move forward? I mean, obviously they affect your ability to hire and the motivation of your employees, hopefully the value that people get for coming to work for you. But you also have to figure out how they factor in as the company moves forward and goes through various rounds of financings. A typical option pool when you first start a company is about 18 to 20%. And then when you go to get your rounds of financing, the VCs will look at how many options you still have available. So not how many options are in the pool, but how many haven't been granted. So if I create a pool with 2 million options, I've given out 1 million of them, I only have a 1 million share available pool. Now the way option pools work, when somebody leaves, their options come back into the pool. But the VC at the time of the financing will look at your available pool. And let's say at that point your available pool is maybe 5% of the company. They often will say that's not enough, and they will make you increase the pool. And they will make that increase effective in your pre-money valuation. So when you figure out the pre-money valuation, what you do is you take all of the shares. Let's say you had a pre-money valuation of $5 million, and you had 5 million shares for easy math. You would have a price of $1 a share. If you had 5 million shares outstanding and a 5 million share option pool, once again to keep it easy math, your price would now be 50 cents a share. So it's important to understand how the size of your option pool is going to affect your pre-money value and the price of the shares. So what you want to do is you want to make your option pool big enough to meet your needs, but you don't want to make it so big that it messes that up. And if the VCs want more in your pool, they'll definitely tell you, but they'll rarely say, oh, your pool's too big, let's decrease it. So that's something to keep in mind. And then when you're negotiating with the VCs and they say, we want you to have 10% of available options, and you don't want to, what you need to do is understand what options you need. You need to look at the company, who's been hired, who needs to be hired, and what your plans are. So if you already have your CEO and your CTO and your vice president of marketing, and you don't have a lot of big hires coming up, you can certainly argue for your stock option pool to be lower. It helps if you've done a budget for the next 12 months and you show it to them and say, see, this is what we figure we need, we'll put in a little extra. On the other hand, if you're getting this financing so you can go out and ramp up your hiring, you're going to be in a pretty bad position to argue that you don't need to increase the option pool. So that's just something to keep in mind when you're sizing it and when you're talking to them about what the size should be and how that affects the pre-money valuation. Finally, you may have heard that in the changes of these tax and accounting regulations, options are now going to be an expense item starting July 1st. And what that means is historically one of the reasons options have been so popular and one of the reasons it's said to have built the valley is that when a company pays you a salary, that's an expense on their financial statements. But when they grant you an option, it isn't. So in essence, it's a way to transfer wealth without having to take an expense at the company level. Starting July 1st, when an option is granted, that's going to be an expense. So that's going to make the company's financial statements look different. How the expense is calculated is still up in the air. There's many different ways, and the rules and regulations are still being worked out. But there will be some way, and there may be a few choices that you can make, but there's no question that options will have to be expensed. And a lot of people are speculating that, especially public companies, are going to start only issuing options to senior executives or really, really cutting back on the size of the grants because they don't want to take these big expense charges. Other people are speculating that investors in the public markets will look past that and kind of figure out what the financial statements would look like without that expense charge. But that's a really big question right now for companies as to how that's going to impact them, and especially since options have been so important so long for so many tech companies, it's a really hot issue that people are concerned about. So that's sort of the quick and dirty overview of options.